Welcome to the Catastrophic Comeback Podcast with American injury lawyer Clark Speaks, helping you find hope, purpose, and joy after a catastrophic injury.
So let's say if a person on January 1st is in some type of accident, and then how long does the typical case, if you consider that most cases don't go to trial, to actual jury verdict, how long would a typical case be from start to finish, would you think?
I think we've run some statistics on this, and I think the average cases are around 8 months. And most of that is treatment time, where the clients are getting treatment, and then we have to collect all that information from the medical providers and the various experts and things that we talk to, and put all that together, send it off, get a custom demand letter written, and then get all that to the adjuster. And then typically the adjuster takes about 3 to 4 weeks to review that. They have to get their authority from the people that, they report to, their settlement ranges of where they value the case, and come back to us with an offer. And then we, negotiate the case at that point. And I've had cases settled in one day if I had an aggressive adjuster who was willing to move and be reasonable. And they got in the range where we wanted them to get. I've also had cases that, the negotiations took several months because the adjusters either were not responsive, or they were difficult, or they, it's just one of those things where the negotiations, every little offer and counteroffer were baby steps and baby steps and baby steps and baby steps. And so it just took forever. So different adjusters like to move different ways. We want to move as quickly as we can for the client's sake, but we don't want to move so quickly that we're compromising the client. We want to get maximum value for the client. So that's our goal, and trying to do it as quickly as we can for the client's sake, but also get the maximum value that we can.
So if it's 8 months, and you say a person was injured in January, and a person is, and the settlement might take place in August, meaning 8 months from start to finish, and realizing that every case is different. Some can't last longer, some are resolved more quickly, for a variety of reasons, treatment, negotiations, and all that. And of course, catastrophic cases are a much different animal, and litigation cases are a much different animal.
Those are years.
But on average, if you're saying that for a normal car accident where somebody's rear-ended on Market Street or Independence Boulevard, that's the range. At what point does the demand fall in that process?
Well, again, that depends on the treatment, how long they treat. Some people treat for 2 months, and some people treat for 2 years, depending upon how serious the injuries are. Once they're finished treating, usually it takes us a month or two to collect all the information. It depends on how much treatment they've gotten and how many providers we have to write and track down. If you're looking at 8 months, that's assuming somebody treats for 2 or 3 months, 4 months maybe, and we've taken a month or so to get the stuff together. The demand letter would come at that point. So, month 6.
Okay.
Or so.
Somewhere around the middle or just past the middle, is where the demand would fall. So, Cooper, let me ask you this. What are the important components of a demand? When you're putting together a demand letter, or when you're, writing about our client's story or a client's story and how they've been impacted by this injury, what are the important components of that letter?
Well, it starts with liability, going through, an accident report, photos, things like that, damages, and then moves to medical damages. All the medical files from, if they went to the emergency department, medications, treatments, detailed. Again, I think you mentioned that insurance companies are willing to pay for cases that are well documented. And so I think it's key to have detailed language. I make an emphasis of using detailed language, not generic. I think a lot of law firms have probably templates, very generic letters that they send out that aren't custom. to adjusters. And if, I were an adjuster receiving that with no detailed descriptions of what happened in the accident, their client ran red light, T-boned our client, or specific, did they receive injections, surgery, like what? And so that is the bulk of the letter, typically medical damages, in terms of the size of the letter. And then finally, lost wages, typically, if there are lost wages, detailed briefly, but, and then attached with, an affidavit maybe. But having a background in journalism, I'm used to citing sources. So you mentioned experts, any that the attorneys have pieced together, a doctor's letter saying this client's going to have residual pain or injuries, possibly. I make a point to not just make this my opinion. This is not my thoughts on what happened. Here's what happened, and here's the source for that. Here's where we got that from a professional.
Well, so let me ask you this, Jeff. Why is that important? What difference does it make if we source and document our sources? Why is that important in this circumstance?
Well, I used to be an adjuster, and I used to do insurance defense work for the insurance companies. And I know, being on that side of it, when I got a demand package from an attorney, if I got, Cooper mentioned generic letters from attorneys. If I got a generic letter from an attorney, and I'm dealing with the same attorneys over and over again as an adjuster, and as attorneys, we're dealing with a lot of the same adjusters over and over again. And if I'm an adjuster and I get a generic letter and I'm seeing the exact same thing, no matter what the client went through or who the client is or whatever, I'm just not even going to read that anymore. Like, I'm just skipping over that cover page. That's going right in the trash can. And I'm looking at the bills and records myself, and I'll put my own spin on what I find as an adjuster. I'm looking for all kinds of problems in the case. That's what adjusters do. They're trying to minimize the payment. So they're looking for gaps in treatment. They're looking for pre-existing conditions, things like that. Maybe areas in the liability case, like maybe our guy wasn't at fault. Maybe this other person, maybe this client was at fault. So, what Cooper's saying there and pointing out, going through liability and the medical reports in detail and citing these things is important, because we want to not make it our opinion. Any attorney can write a letter and just bluster about, how much a case is worth. But when we come in and we say, well, here's what the police officer said. Here's what the photographs show. Your person was at fault, and there's no question about that. And here's what the medical records say. Here's what Dr. Smith or Dr. Jones or whatever, here's what they said about this injury and about the permanency of it and the future medical treatment and all the different, elements of it and why they needed surgery. And they specifically said it was because of the accident. And I've seen Cooper's demand letters, and he's putting stuff like that in those demand letters to point out all of the treatment, all of the injections, pointing all that stuff out. And he's not writing, 10-page treatises, because nobody reads 10 pages anymore. We're in the era of, microwaves are too slow, right? So, nobody's going to read a 10-page letter. So, part of his job is to synthesize all of that hundreds of pages of documentation into a 1-page, 2-page letter, and yet thoroughly cover, here's what this client went through. Because we're giving them a snapshot of our case. Here's what our opening statement's going to sound like. Your guy was at fault. Our lady was injured. Here's what she went through. And here's, the wages that she missed. And here's her damages. And, now it's not an opening statement, but it's a snapshot of it. We're highlighting our case for the adjuster.
And when you say opening statement, just what do you mean by that?
Well, when you get to a trial and you're starting a case out in front of a jury, you're going to give an opening statement. Here's the evidence I'm about to show you. Here's our theory of the case. And the defense is going to do the same thing. They're going to give an opening statement about what their case is going to be about and what they're going to show to the jury. And so we're letting the adjuster know, if this case isn't resolved, this is a snapshot of what we're going to say to a jury when we get in front of them. And so, with Cooper's writing experience, having written, hundreds of articles for online magazines and different things he's written for, he's able to kind of pull those details out and synthesize that very articulately and concisely, so the adjuster will read a 1 or 2 page letter. And particularly if it's different for Mrs. Jones's case, or Mr. Samuel's case, or whatever the client's name is. I'm making those up, but if every letter is a little bit different and customized for those clients and what they went through, then the adjuster is going to read that, because they're going to know it's not some generic template that's coming to them.
So it seems like every time we talk about the building and the development and the creation of these cases in order to maximize value, we always go back to a trial and what this is going to look like in front of a jury and all that. And if I'm, my experience with talking to people who are injured is a lot of them. I used to think when I would talk to people early on in my career, I'd be like, tell them about trials, and I would think they would think, hey, this is great, man. This guy goes to trial, and this guy goes to court, and that's exciting. But what I found is that people they didn't like that. They'd be nervous by that, and so. But the reality is when we're talking about those things, a small percentage of cases go to trial. But in order to get full value, maximum value, we have to build every case as if it's going to trial. Is that fair?
That is exactly what we do.
Thank you for joining us, and we'll see you next time.